and welcome to the Parkinson's Foundation Wellness Wednesday. My name is Laura Summers, and I'm part of the Community Programs team for the Parkinson's Foundation. Today, we are pleased to bring you Advanced Care Planning, Legal Planning. Welcome. As we begin, we want to make sure we take a moment to share the mission of the Parkinson's Foundation. Every day, in everything we do, we are working to make life better for people with Parkinson's. To achieve our mission, we pursue three goals: improve care for everyone with Parkinson's, advance research towards a cure, and empower and educate our global community. Today's program is a great example of one of these things that we are doing to help us meet our goals. Another example of our mission in action is PD generation. This research offers genetic testing for PD-related genes and genetic counseling to people with Parkinson's at no cost. Commit to helping us advance Parkinson's research today. Check your eligibility and enroll now to be a part of PD generation with in-person or telemedicine appointments. You can visit parkinson.org/PD generation to learn more. I'd also like to take a moment to recognize that PD Health at Home is presented by the Light of Day Foundation, whose generosity has made this programming possible. The Parkinson's Foundation has been providing weekly educational and wellness programs virtually through our PD Health at Home series, which includes Mindfulness Mondays, Wellness Wednesdays, and Fitness Fridays. As a reminder, all of these programs are held at the same time, 1 p.m. Eastern, right now, and you can learn more and register for these programs by visiting parkinson.org/PD Health. I also want to remind you that you can learn more about everything that we have to offer the Parkinson's community by visiting our website, parkinson.org, or by calling or emailing our helpline. The number for that is 1-800-4PD-INFO. And now I'm pleased to introduce our speakers from Dutton, Casey, and Mesoloras Attorneys at Law. Helen Messalorus has pre-recorded her presentation. She is a certified elder law attorney in Illinois, and she's been working in the field of elder law her entire career with a focus on long-term planning guardianships, probate and trust administrations, and estate planning. Helen has been named as a leading lawyer by the Leading Lawyers Network since 2020 and an emerging lawyer from 2017 to 2019. Melissa Kaleo will also join us for a live moderated Q&A at the end of this program. Melissa is a certified elder law attorney. She concentrates her practice in elder law, which includes Medicaid planning and applications, adult guardianship estates, trust and estate administration, and estate planning. Melissa has been named as an emerging lawyer and rising star in the field of elder law by the Leading Lawyers Network each year since 2018. As a reminder, today's program will be recorded and will be available to view again in the next few weeks. For now, let's get started with Helen's presentation.
Good afternoon. My name is Helen Messalorus, and I'm one of the principal attorneys at the law firm of Dutton, Casey, and Mesoloras. We are a 6-attorney law firm in Illinois that practices in the area of elder law. Elder law includes estate planning, guardianships, probates, special needs trusts, long-term care planning, essentially issues that affect the elderly and disabled population. Today, the topic for our presentation is a legal roadmap for aging well. Some of the things that we're going to be covering include basic estate planning and what kind of documents should we consider having in place during lifetime, and also what documents do we need after death, especially in order to get our estate to the beneficiaries that we want to leave our estate to. We're also going to briefly touch upon long-term care planning. And what that really means is, how do we plan for the event that we might need care at home, care in a facility, like an assisted living facility or a nursing home, and how are we going to pay for that? So again, some of the items we're going to discuss include healthcare decision-making, financial decision-making and management, care planning, and long-term care costs. So quick overview. Who has the authority to make healthcare and financial decisions? So here we've listed individuals that have the authority to make decisions. So the very first one is the most obvious. To the extent that you're capable of making your own decisions for yourself, you're going to make your own healthcare and financial decisions. And there's a legal presumption that you have capacity. If we have somebody who does not have capacity, then we're going to turn to that agent under a power of attorney. So we might have somebody who's been named in a legal document, like a power of attorney for healthcare or a power of attorney for property, who can step in for that individual because they lack capacity. In Illinois, we have the Illinois Healthcare Surrogate Act. This act is essentially a backup statute for someone who lacks capacity, decisional capacity to make their own healthcare decisions, and they also don't have a power of attorney for healthcare. So under those circumstances, Illinois law has a set of individuals who can step in a particular order to make decisions for that patient who does not have capacity. Lastly, it might be that we have a court-appointed guardian making decisions for someone. So we might have someone who lacks capacity, has not executed powers of attorney for property or healthcare, and we need a decision maker for that person. So that's when we're going into court to ask a court to appoint somebody as that person's decision maker. Starting with powers of attorney, most of you have probably heard of a power of attorney before. There are two types of powers of attorney. One is for healthcare and one is for property. So the healthcare power of attorney essentially allows another person to make medical decisions for the principal. So again, you're designating somebody to make healthcare decisions for you in the event that you can't make them or don't want to make them for yourself. There's also the power of attorney for property. Sometimes this confuses people because most people assume property just includes real estate, but it includes both real and personal property, which means it's management of real estate and of finances. So in the power of attorney for property, you're designating somebody who can help you manage your bill paying, manage your finances, again, in the event that either you want somebody to help you now or you only want them to step in the event that you're not capable of managing your finances. There's some terminology that you should be familiar with in the documents, and that's principal and agent. So the principal is the individual appointing someone, whereas the agent is the person being appointed. And then the agent is legally authorized to act on the principal's behalf. So for example, if I was wanting to prepare a power of attorney for healthcare and I wanted to make sure that my husband could make healthcare decisions for me, I would be the one considered the principal and my husband would be the one considered the agent because I'd be appointing him as my representative. In order to execute a power of attorney, there's a certain level of legal capacity that's needed. And what we're looking at is, does the individual have the ability to understand the nature and effect of the document and the transactions? In other words, if we have a power of attorney for property, does the person understand that with this document, they're essentially giving authority to a person to manage their finances, which means, bill paying, transferring funds between accounts, making withdrawals, selling real estate? Are they able to understand what they're granting to that person? Are they able to also designate who that person should be? And so sometimes when legal capacity is questionable, we might defer to that person's physician to make a determination, but that's what we're looking for in terms of, does this person have the capacity to execute a power of attorney? Starting with getting into more specifics now, we're going to talk about the power of attorney for healthcare before we move on to the financial. So the most states have their own statutory form. So which means that if you want to execute a power of attorney where you live, there's a sample form that you can use that's part of the actual power of attorney statute. And so in Illinois, our power of attorney form, statutory form, says you can only name one person to act at a time. You don't have to use the statutory form. You can use a different form if you want to. Oftentimes it's recommended or preferred that you do use the standard form, in part because it's easily recognizable when you take it to a third party, like the healthcare power of attorney. If you're presenting it to a doctor or to a hospital, they're familiar with the standard form. And there may be some legal protections too if you're using a standard form. In any case though, the power of attorney for healthcare statutory form says you can only name one person to act at a time. So you would name one person to act, and then you'd want to make sure that you name successor agents. So one thing to keep in mind is just because you name somebody in a document doesn't mean that they're obligated to act. You always want to have that discussion with that person beforehand, letting them know that you'd like to nominate them and list them in your documents. Especially for healthcare, those decisions are often very difficult decisions, and you want to make sure that the person you're naming is willing to step in and also willing to follow your instructions. So we're going to name one person to act at a time, and we're going to want to make sure we name backups in the event that the person that you've named either is not available or unable to make decisions or doesn't want to act. We want to make sure we have succession. With regard to the power of attorney for healthcare, sometimes the question comes up, well, can we change it? So it is revocable even without capacity. So at any time, the healthcare power of attorney can be revoked, even if we have a person that's not competent. This sometimes confuses people because how can somebody who doesn't have capacity revoke something? But there's a specific carve out with the power of attorney for healthcare regarding this. And when we end up in this situation where we have a power of attorney for healthcare that's essentially being revoked by somebody who lacks capacity and needs a decision maker, it might be that we end up in guardianship court at that time. The power of attorney can be amended with capacity. Note, though, that signing a new power of attorney revokes the old power of attorney for healthcare. So the form will say when you sign it that any prior powers of attorney are revoked, and essentially the new form that you're signing is replacing any prior documents. And that's in part because we don't want multiple powers of attorney floating out there, especially if they're listing different agents. On the power of attorney for healthcare, you're also going to need to designate when it becomes effective. In other words, you're signing this document, you're naming an agent. When can the agent actually step in and act for the principal? So the power of attorney for healthcare standard form actually gives you three options. One option is that you only want your agent to step in if the doctor determines that you lack decisional capacity. So if the doctor determines you lack decisional capacity and you're unable to make your own healthcare decisions, then you want your agent to step in. Another option is that you only want your agent to step in if you lack decisional capacity, except starting at the time that you sign the document, you want your agent to have full access to your medical information. So there's a built-in Hipaa release. So that would be the second option, but the authority is still the same, where the agent wouldn't have any authority unless there's a doctor determination that you lack decisional capacity. The third option is that you want it to become effective immediately, that you're allowing your agent to make healthcare decisions for you, except to the extent you want to make your own healthcare decisions, you reserve the right to do so. So this is laid out in the form. The statutory form has these three options, and the principal will choose one of those forms, but the document will need to say when the power of attorney becomes effective. The form can be customized to the values of the principal. So that's a discussion that you're going to want to have with your attorney. If you feel strongly about certain types of medical treatment or life-sustaining treatment, you're going to want to make sure that you include those instructions in the document. Sometimes we include some instructions that we want the agent to consult with other people. So even though we've only named one person to act at a time, we maybe want there to be a family discussion about the decision. So sometimes clients will ask us to say, well, can I direct my agent to at least consult with my children or consult with so-and-so in making the decision, even though the agent will have the final say. When an agent is acting, this is very important. When an agent is acting, they're supposed to use a substituted judgment standard in making decisions. So this is the legal standard that the agent's supposed to use. So what that means is that to the extent the agent knows what the principal would have wanted, they're supposed to follow those instructions. To the extent they don't know, then they would do what's in the best interest of the principal. And although the agent has no duty to act, it must be with due care for the principal. Going back here though, one other thing I want to mention is sometimes another document that we'll prepare with the power of attorney for healthcare is a separate Hipaa release. So where we're naming one person to act at a time, and maybe we have a client who has 3 children and wants all 3 children to at least have the ability to talk to doctors and talk to the hospital staff. We'll prepare a separate form which says that, these 3 individuals have authority to obtain medical information, talk to the physicians, even though they're not an actual decision maker under the healthcare power of attorney. Because remember, we can only have one person to act at a time. So sometimes we'll prepare that document too, where we want to encourage the sharing of information. So we'll do a separate Hipaa release authorizing more than one person to have access to medical information. The Healthcare Surrogate Act, as I mentioned before, is the backup statute here in Illinois that lists out a priority of surrogate decision makers in the event that we have someone who lacks decisional capacity and who does not have a power of attorney for healthcare. And this is the order. So you'll see the first person is the patient's guardian, if there is one, otherwise it's spouse, any adult child, either parent, any adult sibling. So many times this list will actually reflect what most people would want naturally. But part of the problem too is, especially categories like 3 and down, any adult child, either parent, any adult sibling. You might have more than one child, and you might have more than one child that's not in agreement. And so thinking about who you want to make your healthcare decisions in advance is a good idea to help prevent any kind of problems down the road, especially if we have multiple people that fall into the same category. Moving on to the second type of power of attorney is the power of attorney for property. Before I go there, I do want to mention that sometimes the question comes up, well, I'm in Illinois, I'm going to execute the Illinois form, but what if I move? If I move, what do I need to do at that point? Are my documents still valid? What should I do? So what we always recommend to clients is if you are moving to a different state, you're going to want to consult with an attorney in that state, because as I mentioned, each state has their own forms, each state has their own requirements, and each state also has their own rules about out-of-state forms or non-statutory forms. So like in Illinois, if you have an out-of-state form, but it complies with, complied with the rules in that state, then Illinois will honor that as a valid power of attorney. Some states say, you have to have a minimum of 2 witnesses and a notary or something like that. So it really depends state by state. There will be some provision in that state law about, out of state in non-statutory forms. So the power of attorney for property, as I mentioned, is the one that deals with finances and like real property. And in order to execute the power of attorney, we want to make sure the person has legal capacity. And again, what we're looking for is, does the person understand what the document says, what kind of powers they're giving to their agent, and are they able to designate that agent in the document? It also, so it requires contractual capacity to execute. It also requires contractual capacity to revoke. So this is an important distinction. Once a principal becomes incapacitated, neither the principal nor the agent can change the power of attorney or execute a new one. So this is what's different too about the power of attorney for healthcare, where it can be revoked at any time, regardless of capacity. The powers of the agent are defined in the statute and are very broad unless they're modified in the document. They do not include gifting unless specifically included in the document. So what that point is including is that if you've ever seen the Illinois power of attorney form for property, you'll see it's very broad. On the first page, it'll list categories of decision-making that the agent has authority over. So for example, it'll say my agent has the authority over real estate transactions, retirement accounts, safe deposit box, brokerage accounts and mutual funds. It's very broad, but there are certain things that by law, the power of attorney agent does not have authority to do on the principal's behalf unless it's specifically included in the document and added to the document. So it's paragraph number 3 on the Illinois form. And it says, if you want to give your agent additional authority, here's where you can do it. And here are some examples of provisions you can add to your document. And so the form actually gives you a few examples. It says here you can add the power to make gifts, the power to change beneficiaries, the power to revoke or amend a trust, Those are just some examples that if we don't actually type those in and include those in the document, the agent wouldn't have authority to do on the principal's behalf. So then the question is, well, why would you ever want to give your agent more than what the standard form allows? Why would you want to give your agent the authority to make gifts or the authority to change beneficiaries on your accounts? Sometimes those powers are important for long-term care planning purposes. So if we're maybe concerned about Medicaid planning down the road, and we want to make sure we have the ability to transfer assets between spouses, or maybe set up certain types of trusts or make gifts to children as part of an overall plan, we would want to include those powers. Sometimes we also want to include like gifting powers because maybe we have an estate tax issue. So we want to maximize our ability to gift the annual exclusion to family members. But in any case, the main point here is that, when you're having your estate plan prepared by your attorney will discuss with you, what the power of attorney covers and, whether or not we want to include and whether or not it's appropriate to include additional powers so that your agent would have above and beyond what the standard form would allow. Just like the power of attorney for healthcare and the power of attorney for property, we need to designate when the form becomes effective. In other words, when can the agent use the power of attorney? When can they actually go to the bank and, transact on an account? So in the power of attorney for property, you're going to make that designation. And usually it's one of two situations. Either you're going to say it becomes effective upon signing, which means that no other document is needed other than the power of attorney for property in order to have the agent step in, or you're going to delay when the agent can step in, and you're going to say, I only want my agent to step in if there's a doctor determination that I lack capacity. Maybe it's one physician letter, maybe it's two physician letters, which would then mean that before the agent can step in on the principal's behalf, they would have to have that physician form and determination that you lack capacity. So there's like that extra step and extra documentation. Keep in mind that just because you make the form effective immediately doesn't necessarily mean that you are restricting yourself in making decisions. So to the extent that you can continue to handle your own finances, you'll have the ability to do so. If you make it effective immediately, it just means that your agent also can step in and they wouldn't need any other documentation in order to do so. If a document was executed during a period when the principal lacked capacity, they are subject to challenge and can be invalidated by a court order. So sometimes we have powers of attorney that are signed, witnessed, and notarized, but the principal really didn't have capacity to understand that transaction. And many times in those situations, we end up in guardianship court, where we're petitioning to have that power of attorney essentially revoked and invalidated and have a court-appointed guardian to serve as that person's representative. If we have an agent acting, there are certain legal responsibilities. So the agent is required to keep records of receipts, disbursements, and other significant actions. They also have a duty to account. The agent must provide, upon request, a copy of receipts, disbursements, significant actions to principal or fiduciary on behalf of the principal, Adult Protective Services Agency, ombudsman, or the public guardian or court. So by statute, there are certain people and agencies that if it's requested of them, the agent has to provide an accounting. Sometimes in our office, we will expand this duty to account. Again, in the power of attorney, we can only name one person to act at a time. We might have multiple family members, and we might have a client who wants to encourage the sharing of information. So sometimes we'll have language in our form that says, any of these people can ask for an accounting from the agent, and it might be it might be their siblings or other family members. Again, you can customize the power of attorney for property, just like you can the power of attorney for healthcare, to reflect what your client's goals are and what their wishes are. The agent can delegate authority to others. So under the standard form, there is a paragraph that says the agent has the authority to delegate authority to others. If that was something you did not want to allow your agent to do, then that's something you can just delete and strike from the document. Same with the agent being entitled to reasonable compensation. So under the standard form, there's a paragraph that says that if you did not want your agent to be compensated for serving as your agent, then that would be something that you can strike. Just keep in mind though, that just because that language is in the document, it doesn't mean that your agent is actually going to be compensated. It would just allow them to be compensated under the form. And if agent compensation was something that was being contemplated, that would be something that would be taxable to the agent as income. They would keep records of what it is that they're doing. So if you have an agent acting for a principal and they're working on selling that principal's house, they're handling the bill paying, they're, contacting the retirement account to, handle the required minimum distribution, they would keep records of what they're doing, how long it's taking them, and then they would be paid typically on an hourly rate. So moving on, we're still in kind of the financial decision-making part of the presentation. Joint tenancy, we have this under this part too, but it also kind of taps into the second part of estate planning, which is what happens to your estate at the time of death. And so before I talk about joint tenancy, I just want to back up and just kind of summarize what we've already talked about. So we've talked about powers of attorney for property and healthcare. Those are lifetime documents. Those are documents where we're appointing a decision maker during lifetime to either handle our healthcare decisions or handle our financial and property decisions. And essentially those authorities terminate at the time of death. Power of attorney for healthcare extends post-death for purposes of handling a burial and funeral, but otherwise those are after death, those are no longer valid. So the second part of estate planning is, what happens to our estate at the time of death? And many times it involves a discussion about, well, what is probate? Many of you have probably heard of probate, and what you've probably heard about probate is that you want to avoid it. So before we talk about that, before we talk about joint tenancy, I just want to explain what probate is, because then I think this slide and the following slides will make more sense. So many times people think that if they have a will, their estate will pass according to what their will says. Well, you're right. I mean, that makes sense. Like, what's the purpose of a will? The purpose of the will is to distribute your estate at the time of death. However, in order for the will to be effective, it has to be a probate asset. So in other words, whether or not the will is going to apply, we need to look at what the person that passed away owned at the time of death and how it was owned. So there are essentially three ways that we avoid probate, and probate is a court process. It's a court process where we have to open up an estate and go through a court proceeding in order to collect assets and distribute according to a will. So the very first way is with joint tenancy. Joint tenancy is a form of joint ownership whereby each owner owns 100% of the property. And at the death of one of the joint owners, the surviving owner owns the entire property. So for example, if you have jointly held real estate, maybe between a husband and wife, we know that if it's jointly held upon the first spouse's death, that property is going to transfer to the surviving owner. You have two owners, one dies, the surviving owner becomes the sole owner. So we never look at the person who died, the deceased spouse's will, because that property was held in joint ownership. Or same with like a bank account. You might have, again, a husband and wife, jointly held checking account, first spouse passes away, that account will pass to the surviving spouse just by virtue of how the account is set up. So we'll never look at the person's will. So some of the advantages to joint tenancy is, it does avoid probate, at least on that first owner's death. There's no cost generally to set it up. Like you go to the bank or you take title to real estate, there's usually no cost to have two owners. And also it can help manage that asset during incapacity, especially with like a bank account. So if you have two owners on an account and one of the owners is not competent, you have another person on that account who has complete access to the account. Some of the disadvantages to joint tenancy is it's risky. Joint tenancy has an ownership interest in the property, and the property is available to the creditors of the joint tenant. So essentially, if you're naming somebody as a joint owner, that person has equal access to the account, and if that person has any kind of creditor issues, that's part of their estate as well. It does not allow for contingent beneficiaries. So, For the example here, and kind of goes to the other points too, is, if you have maybe a mom who names one of her children on the account as a joint owner, but she has 3 children, and her intent is that she wants that account to pass to all 3 children. If you have a jointly held account, by law, at the time of her death, it would just transfer to that surviving child. And then it would be upon that surviving child to, potentially honor her mom's wishes and, distribute the funds to her siblings as well. So sometimes the use of joint tenancy doesn't reflect what the person's estate planning goals are. And that's the next point too. Surviving joint tenant is entitled to the entire property at the death of a joint tenant, where there are several persons who are the beneficiaries. It's difficult to name all as joint owners. And the other thing too is, sometimes people want to provide for grandchildren in the event like their child is deceased. So with joint tenancy, you wouldn't be able to do that. Let's just say we had a mom, she listed her 2 children on the account, and at the time of her death, only one was surviving, but she would have wanted that deceased child's children to receive. The joint tenancy wouldn't accomplish that. Lastly, Medicaid applicant is presumed to be 100% owner of all personal joint property. And this is a really important point. So as part of, many of you probably are familiar with what Medicaid is. So Medicaid is a state and federal program, health insurance program, and where there are certain financial requirements in order for Medicaid to be a payer source. Oftentimes we're thinking about Medicaid in terms of a nursing home, so that Medicaid can pay for the nursing home services. And one of the rules that Medicaid has as part of the application process is that, a disclosure of all the person's finances. So if you have somebody who is on the account, Medicaid presumes that that person is the owner. So in other words, Medicaid applicant, let me just clarify that. So let me give a good example here. So we've had cases before where we've had people add on their elderly parents onto their account for estate planning purposes only. And then that elderly parent has to go into a facility. And as part of the Medicaid application process, Medicaid wants to know what do you own? Where is your name on? What accounts are you named on? And I had a case once where we had a single man who named his elderly mother on all of his accounts. And then she needed to go into a nursing home and apply for Medicaid. So here we had her listed on all of her son's accounts, and we had to disclose that to Medicaid. And under the Medicaid rules, Medicaid presumes that these are mom's accounts because her name's on it. And so we had to provide evidence to Medicaid to show them that, yes, mom's name was actually on these accounts, but she was never really an owner. She never contributed to the accounts. Her Social Security wasn't used for the accounts. None of her expenses were paid from the accounts. But, it was a lot of paperwork and a lot of convincing, because Medicaid is automatically going to presume it's the applicant's account. So just pointing that out as, potential disadvantage. The second way we avoid probate, is, well, before we get to trust, let me say that the second way we avoid probate, which we don't have a slide on, is beneficiary designations. So we know that joint tenancy on the first owner's passing, that account will transfer to the surviving owner. The other way we avoid probate is if we have an account with a beneficiary designation. So for example, life insurance policies, retirement accounts, annuities oftentimes have a beneficiary. If the owner has designated in advance where the money goes at the time of their death through that designation. And oftentimes we can name a primary and we can name a contingent beneficiary. So if that first person that we've named as beneficiary is not living, then we've essentially named a backup. So beneficiary designations also avoid probate, which again means that if the owner, so if my husband has named me as beneficiary on his retirement account at the time of his death, provided that I'm living, I can collect that account. We will never have to look at his will, and his will could say something totally different, but it wouldn't even apply. So second way we avoid probate is with beneficiary designations. The third way is with trusts. What is a trust? Many of you have probably heard of a trust. some of you might even have a trust, but essentially what a trust is, it's a legal arrangement through which one person or an institution holds legal title to property for another person. And the rules, instructions under which the trustee operates are set out in the trust document. There are different types of trusts, revocable and irrevocable. So essentially what it is, it's a legal document. So it's a legal document that you prepare. It acts like a will in that it will say where anything that's part of this trust passes at the time of the person's death. But it also is different than a will because it applies during lifetime. So during lifetime, this document will say anything that's part of the trust, this is how the trust property should be distributed. And then at the time of death, this is how any trust property should be distributed. So let me just give you an example. So let's just say I wanted to set up a trust. I would call it the Helen Messalorus Living Trust. And I would designate who would be the trustee. So the trustee is the manager of this entity that I'm creating. So I would name myself, like I want to be the manager of my trust. And then there would be sections in the document that say what happens with the trust property during my lifetime. So during my lifetime, anything that I put in my trust, I want it to be used for my benefit. So I'm going to say I'm the primary beneficiary during my lifetime. And then I'm going to have a section that says what happens during my incapacity. So I'm going to say I still want to be the beneficiary, but I'm going to list backup trustees who can step in and manage the trust for me. And then I'll have a section 2 that says what happens with this trust property at the time of my death. And so that's where I would list my beneficiary designations. So a trust document is a way that you can manage your finances during lifetime and after death. And it's an effective way to avoid probate as well. So, what is it used for? I mentioned that it's used for probate avoidance. Instead of going through the court at the time of the person's death, who created the trust property passes to whomever is named in the trust. So we don't have to go into court at the time of death, provided that it's part of the trust. It provides a way for asset management. It allows the trustee to administer and invest the trust property for the benefit of one or more beneficiaries of the trust. Sometimes we're using a trust for tax planning purposes. The trust can be drafted so that the assets will not be included in the estate of the beneficiaries, thus avoiding taxes when they die. So if we have a taxable estate issue, a trust can be used to take advantage of the estate tax exemption. It also provides for disability planning. So wills only provide for death. So wills only apply at the time of death, whereas trust can help a person have a plan in place in the event of their own illness, which is one of the examples I had provided, that if I have a trust document, there's going to be a section that says who's going to step in to manage this trust if I'm unable to manage the trust because of my incapacity. Some of these points to are individuals who have been adjudicated incompetent by a court may still have testamentary capacity to execute, amend, or revoke a trust. It can be established by the principal's agent under a power of attorney for property. So a trust can be established by the agent of the power of attorney for property if that specific power is granted in the power of attorney documents. When an individual under guardianship lacks testamentary capacity, the court may authorize the guardian to engage in estate planning on behalf of the individual. So what this point is just making is that sometimes we have somebody who lacks capacity to create a trust, but we might have another decision maker who can create the trust for them, whether it's a power of attorney for property or maybe a court-appointed guardian with court permission. Some of the duties of a trustee include to invest and administer the trust assets. They have a loyalty to trust beneficiaries, no self-dealing, and they must provide an accounting to trust beneficiaries in compliance with the terms of the trust. So this kind of goes back to just generally what kind of legal duties does a fiduciary have? So just like an agent has certain duties to the principal under a power of attorney, a trustee has certain duties to the grantor of the trust. And so this is especially important really when we don't have the same person serving as trustee. Some of the disadvantages to a trust, if you want to consider that, it's a more expensive document to create. So it's a more complicated legal document to create, so obviously there's more legal fees involved. Assets must be transferred to the trust, which is time consuming. Assets must be held in the trust, which requires lifetime administration. And the trustee has authority over trust assets and is limited by the terms of the trust document. So what I want to really just point out here is that if you decide to do a trust, there's really kind of two steps. One is actually executing the document. So you have this document that you've executed, you've created this trust, but in order for the trust to be effective, you have to make sure that you coordinate your assets with the trust. What does that mean? It means that in order for the trust to control and provide instructions regarding to that asset, it has to be part of the trust. How do we make it part of the trust? Well, we make it part of the trust with either having that account retitled into the trust or naming the trust as the beneficiary. So for example, if I have a checking account in my name only, and I've created a trust, if I want that checking account to pass according to what my trust says and be administered according to what the terms of my trust says, then I want to make sure I go to the bank after I've executed my trust and tell the bank, I want to change the ownership. I no longer want to be the owner individually. I want my trust to be the owner. So change the ownership to Helen Messalorus as trustee of the Helen Messalorus Trust. And so the account would still use my social security number for reporting income, but then it would be part of the trust. It would be administered by the trustee of the trust, me while I'm capable, somebody else while I'm unable to. Or maybe I decide I have a life insurance policy. How do I make this part of the trust? Rather than maybe listing my husband or my daughter as the beneficiary, I'm going to go to the life insurance company and say, I want to change the beneficiary. So at the time of my death, I want this, the benefit to pass according to what my trust says. So instead of naming individuals as the beneficiary, you would name your trustee of your trust as the beneficiary. The funding of your trust is a really important step, because if you don't do that, then you essentially have this trust document that's not effective. And so if this is something that you're considering having created for yourself, your attorney will guide you through that process. Like once the document's actually executed, what are the next steps to make sure that this trust is effective in distributing your estate according to the terms of the trust? Well, we've been talking about our revocable trusts. So that's your typical estate planning trust, where you set it up, you want to provide a way to avoid probate, you want to provide a way to manage your assets during lifetime, but you also want to reserve the right to change it over time. So a revocable trust is one where you can revoke it at any time, you can amend it at any time, as long as you're competent. So if you decide you want to change the trustees, or if you decide you want to change the beneficiaries, you have the ability to do so. You might even decide you don't even want the trust anymore. You have the ability to just revoke it and get out of it. So oftentimes when we're talking about estate planning, we're preparing a revocable trust. There are other types of trusts that are irrevocable, which means that it cannot be changed or amended. So you set up this trust document, and once it's set up, you can't change the document, or once you've added property into the trust, you can't then take the property out and revoke it. It would be governed by whatever the terms of that trust say. Why would we ever want to set up an irrevocable trust? Well, there are certain situations where the trust has to be irrevocable for tax planning or long-term care planning purposes, which I think we have in some other slides. But the point here is that there are different types of trusts. So either it's going to be a revocable trust or an irrevocable trust. Whether we can change it or whether we cannot change it is that distinction. There's also testamentary trust, which is a specific type of trust created by a will. So the trust actually is in the will. So the will document creates the trust. And there's no effect of that trust until the will of the donor is probated. And it can be useful in accomplishing certain estate planning goals. Oftentimes in our practice as long-term care planning attorneys, we use a testamentary trust. So again, it's a trust in a will. It's not an actual separate trust document. When we have, and when we're doing Medicaid planning for spouses. So the testamentary trust is used in specific situations where we don't want the trust to become effective until the time of death, and only if the will needs to be probated. Again, the point here is that there's just different types of trusts, and your attorney will discuss, what kind of trust is appropriate in your particular situation. Special needs trust is another specific type of trust. Oftentimes they're called OBRA trusts. It can be used to assist a person who is or may become eligible for SSI or Medicaid. Can be established by the individual, a parent, grandparent, guardian, or by court order. Most special needs trusts are irrevocable, and there are several types for people either under the age of 65 or over the age of 65. So essentially, what a special needs trust is, it's a specific type of trust that can be created for somebody who is on public benefits like SSI or Medicaid, and they still want to qualify for their benefits. So SSI and Medicaid have financial requirements. So if you exceed certain asset limits, typically $2,000, you're not going to be eligible to receive those benefits. But so there are situations where maybe we want to have funds set aside and still qualify for those benefits. And the special needs trust is a type of trust which will allow the person to still qualify for those benefits, even though there might be $50,000 or $200,000 set up in a special needs trust. And here, the slide is pointing out, again, there are different types of special needs trusts. One type is called a first party special needs trust. So you have an individual who maybe is going into a nursing home, they have $100,000, they're 60 years old, and the question is, well, they want to qualify for Medicaid so that Medicaid can pay for that nursing home care, but do they have to spend all their money down to $2,000, or is there some way that maybe we can set that money aside for them? So a first party special needs trust is a trust set up by the individual themselves and with their own money. So in my example, this person who might have $100,000 going into a nursing home under the age of 65, they could take that money and put it into this special needs trust and still qualify for Medicaid benefits. The advantage to that is that the money would be there to provide for their supplemental needs during their lifetime. So if somebody's in a nursing home on Medicaid, Medicaid's going to pay for that person's care. But what if that person needs dental work that Medicaid won't cover, or maybe they need a better wheelchair or new hearing aids that Medicaid won't cover? Maybe we just need a caregiver a few hours a day. That money could be used to provide for those items during their lifetime. One of the reasons Medicaid does allow this type of trust to be set up is that if the person is setting up the special needs trust with their own money, at the time of that person's death, any money that's remaining in that account would be subject to a Medicaid payback, which means that Medicaid would be entitled to recoup what they've paid out on that person's behalf. But the advantage to setting it up is that during lifetime, that money can be used, and it might be that there won't be any money left over at the time of death for Medicaid to be reimbursed with. That's one example of a special needs trust. You have an individual that is, has a disability under the age of 60, looking to qualify for SSI or Medicaid, and they take their money and put it into this special trust. The second type of special needs trust is called a third-party special needs trust, where you have a third party setting up a trust for a person with a disability. So the example here is maybe you have a parent who has a child with a disability, and they want to provide for that child at the time of their death, but they want to make sure that they don't jeopardize their eligibility for any public benefits that they're on. We know if they left any money to them outright, that would be a problem for SSI or Medicaid. So they might instead, as part of their own estate plan, decide to provide for that child through a special needs trust. So rather than making their distribution directly to them, they would put the money aside into this trust that, again, can be used to provide for anything that SSI or Medicaid is not providing. The main distinction between the third party and the first party special needs trust is that the third party special needs trust does not have a Medicaid reimbursement requirement at the time of the person's death. So at the time that that child passes away, that parent can designate in the trust document where any remaining funds would go. So there's no Medicaid payback requirement. in a third-party special needs trust. Our last topic is care planning and long-term care planning. So what we've talked about, again, so far, we've talked about the powers of attorney for property and healthcare, lifetime documents. We briefly talked about post-death administration and how we avoid probate, joint tenancy, beneficiary designations, and a trust. And we talked about different types of trusts. Before I go into the care planning and like long-term care planning slides that we have, I want to mention then, because I didn't mention this, is what is probate then? When do we end up in probate? So we end up in probate when we have an account or an asset in one person's name only, with no beneficiary, no joint tenant, and no trust. So a good example would be if I own my home in my name only, then at the time of my death, if my husband's not a joint owner, I don't have a beneficiary on it, it's not in a trust. At the time of my death, in order for my husband to be able to sell the home, he would need to go into court with my will, get appointed as an executor or representative, and then he'd have legal documentation that he could use to sell the house and distribute, the proceeds according to what my will says. Some of the reasons that people want to avoid having to go into probate court include the legal fees. An attorney has to be hired at the time of that person's death to handle the court proceedings. Another reason is lack of privacy. It is a public proceeding. The will gets filed. The court documents are public records. And I would say the third reason that most people want to avoid probate is based on the delay in distribution. So under the probate statute, there will be a certain period of time that the estate has to stay open and no distributions can be made to beneficiaries in case there's outstanding debt out there. In Illinois, the period of time is 6 months. So a notice gets filed once an estate is open. The estate has to stay open for 6 months. And during that 6-month period of time, the estate can be administered. It's just no distributions can be made to beneficiaries. Because what we're waiting for is waiting to see if there are any creditors out there that are due funds, there's debt. And to the extent that there is, they could file a claim against the estate. So that's probate. Probate is, again, it's a court process. Whether or not we need to go into probate court at the time of the person's death depends on what the person owned at the time of death and how it was owned. So oftentimes when we're doing a consult after a person has passed, what we're looking at is give us the financial information. What did this person own? Was anything in joint tenancy? Were there any beneficiary designations? What was in that person's name only? What kind of debt did they have too that you're aware of? So we can determine whether or not we need to go into probate. Okay, moving on to our last topic is really kind of care planning and long-term care planning, which we're just going to briefly touch upon. So care planning, there's a few other forms that we wanted to mention as part of care planning. We already talked about the power of attorney for healthcare. I mentioned the Hipaa release, but another form that you should be familiar with is the post. So essentially what the post is, it's a revised version of the DNR. It's a medical order reflecting a person's wishes that travels with the person across settings of care that must be honored by all healthcare providers. It's a form that's intended for a person who is seriously ill or with a life-limiting illness. It's completed after a patient discusses their preferences with healthcare professionals, and it's signed by the patient or patient's representative, an attending physician, and a witness. So the post is certainly something that comes up in our practice, but it's not a form that we as the attorney will prepare because it involves the signature of a physician. But it's something that we discuss with the client to let them know that this is an option and a form, and we encourage them to discuss it with their healthcare professionals. But it's part of just kind of care planning in general. Another form we wanted to mention is the 5 wishes. This is, which some of you might be familiar with. The 5 wishes is a national document. So it's legal in 42 states. It's available in 29 different languages. So it's not specific to Illinois. And essentially what it is another type of advanced directive where it addresses healthcare decisions. So it's written out in everyday language and includes instructions to complete it. It covers personal, spiritual, medical, and legal wishes all in one document, and it's valid in most states. So oftentimes, the statutory power of attorney for healthcare is kind of a bare bones form that doesn't really allow people to make to provide specific instructions. At least in Illinois, the form is pretty bare bones. There's a certain section where you can include some instructions, but if you wanted to provide some more instructions, the 5 wishes goes into greater detail about different types of treatment during different types of conditions. It goes into even like funeral wishes as well. When this comes up in our practice, sometimes clients will say, I want to do the 5 wishes form as my power of attorney for healthcare, which is fine. The 5 wishes form can be used as the person's power of attorney for healthcare, but it would be considered a non-statutory form. Most of the times though in our practice, we will use it as a supplement to the power of attorney for healthcare, so that the official legal healthcare document would be the power of attorney for healthcare. But to the extent the client wanted to provide some more detailed instructions, we might reference the 5 wishes in the power of attorney for healthcare, or sometimes we'll even incorporate some of the language in the 5 wishes in the power of attorney for healthcare. But essentially, it's just another legal healthcare document that you should be aware of that's an option. Again, it'd be considered a non-statutory form, but which is still legal. It's just not the standard form that most states use. Lastly, we're going to talk about long-term care costs and what is long-term care. So again, remember the topic is the legal roadmap to aging. So what we wanted to address in our presentation today was kind of basic estate planning, documents during lifetime, documents after death, but we also wanted to touch upon long-term care planning. So what is long-term care? Long-term care is medical and non-medical care given to people who are unable to perform basic activities of daily living. When we're talking about long-term care, it includes care provided in the home, in the community, or in long-term care settings like assisted living or skilled nursing homes. It can be needed at any age, and Medicare and most health insurance plans don't pay for long-term care, which is really an important point. So what does Medicare pay for? Many of you might know that Medicare will pay for up to 100 days of skilled nursing home care provided in a Medicare certified nursing facility following an inpatient hospitalization of at least 3 midnights. So Medicare will pay the full cost of the first 20 days. And if there's supplemental insurance will pay for days 21 through 100. And then Medicare will provide some home care, but if it's somebody who needs long-term custodial care, Medicare would not cover that in home. So here the point is that Medicare will cover a certain period of time for somebody who needs skilled nursing care, but Medicare is not meant to pay for someone who needs to reside in a nursing home. So at that point, we're looking at what are the other options for payment. So we're in a nursing home, we've exhausted our Medicare days. What are the options? So the options include, first, private paying. So you have money in your bank and your retirement accounts, and you're just going to private pay whatever the cost is at the nursing home. It might be that you have long-term care insurance. Long-term care insurance is the only health insurance that will pay for custodial long-term care, either at home or in a formal care center. So it might be that you have long-term care insurance that will help pay for that care in the facility. Most people don't, but there are certainly people that do. The third way is Medicaid. So with regard to long-term care insurance, sometimes what we're looking for when we do see long-term care insurance policies, or we're counseling somebody who's considering purchasing long-term care insurance, there are different types of policies. Some long-term care insurance policies have a combination with life insurance, so that if you don't tap into the long-term care insurance benefits, there's a life insurance component to the policy. We're looking at what kind of premiums are associated with what kind of benefits that they will provide. Spousal portability, can the policy be used with both spouses? What's the maximum daily benefit? What's the maximum lifetime benefit? Are there home care benefits that are included? Are there care manager benefits? So nowadays, most policies include, benefits for home care, assisted living, and nursing home care. And they even include provisions for care manager, being able to hire a care manager under the policy and have the policy pay for that. Lastly, Medicaid. Medicaid, we can have a whole presentation on because the rules are very complicated. But we just wanted to point out the kind of basics of Medicaid in that I had mentioned earlier, it's a federal and state program. So while there are federal laws about Medicaid, each state also has their own regulations and policies. So just because you might qualify in one state doesn't necessarily mean you'll qualify in another state. We'll sometimes have clients though too who are Medicaid in one state and move to a different state, and then we just have to transition them to the Illinois Medicaid. But each state will have, like I said, their own regulations. In Illinois, the Medicaid agency is the Illinois Department of Healthcare and Family Services. And eligibility, though, is determined by the Illinois Department of Human Services. Medicaid will cover nursing homes, supportive living facilities, community care program, and in-home services. So nursing homes and supportive living facilities are actual facilities. Community care program and in-home services are home services. So sometimes the question is, we have somebody who needs care services, they're still living at home. Does Medicaid provide for any services? It depends. So if they're over the age of 60, there's the community care program. If they're under the age of 60, it's in-home services. Those notations on those bullet points that say waivered essentially means it's a Medicaid program where funds are being used in a different way than nursing homes to provide for that care. Nursing homes are your most traditional Medicaid eligible places, especially when we're talking about long-term care. Supportive living facilities are kind of like assisted living facilities. Is for people that don't need as much support, but they need some supervision. So if the facility is licensed as supportive living, we know that it will accept Medicaid, provided that the person meets the Medicaid rules. And like I said, the community care program and in-home services are both Medicaid programs for people in the community. So it's somebody that we're trying to keep in the community, not having to move them into a facility. And it might be that we qualify for certain services like, a caregiver, a certain amount of hours a week, meal preparation, basic housekeeping, but those are some other Medicaid programs. I believe my time is up now. So I really appreciate everybody joining us today. I hope that this presentation has been helpful, and we are ready to take any questions. Thank you.
Wonderful. Thank you so much, Helen, for your presentation, and welcome to Melissa. We are going to go ahead and get started with our Q&A session now. So folks, you can continue to enter your questions into that Q&A button at the bottom of your screen, and we'll continue to compile them and get through as many as we can. But welcome, Melissa.
Hi, thank you so much for having me.
Wonderful. All right, so there are a couple of questions that came in during the presentation, a couple of questions that came in during registration. I'm going to start off with one of these that is maybe a little bit trickier. So how would someone might go through finding and screening for a trusted and affordable attorneys or folks who might be helpful to navigate this process?
So obviously I'm going to be a little bit biased here because I am an attorney who does routinely assist clients and people in this process, but I'm also realistic in that I know that I may not be the right attorney for every single person. Everyone has different goals, different ideas, and everyone works a little bit differently. So I think it's very important that you engage the services of an elder law focused attorney, as opposed to perhaps just an estate planning focused attorney. Elder law attorneys are going to have an eye for issues that really you're going to encounter as you go through kind of the aging process or receive a certain diagnosis. So that's my first general recommendation. There's our firm and many other respected elder law firms are part of the National Academy of Elder Law Attorneys. They have a website with a search where you can find someone in your area who is affiliated with that organization. So I think that would really be my first step, is identifying an elder law attorney. From there, I think it's about kind of your preferences for attorney. Do you want someone who is in your local area who you can just drive 5 minutes to be able to see, or are you more comfortable with phone or Zoom conversations? So it's really going to be personal preference. But I think the biggest thing that I can recommend is to make sure that it's an attorney focused in the elder law area. They're just going to be able to, I think, not only do that estate planning for you, but also be attuned to issues that you may not even know are actual issues. I think especially with our firm, we are very focused on not just doing the estate plan, but also giving you information and giving you referral sources to kind of comprehensively address everything that you could be dealing with. Because as attorneys, we recognize that, hey, some of these questions, while they logically come up when you're dealing with an elder law attorney, they're not best answered by us, and we need to connect you with other professionals. So I think you're going to get that with an elder law attorney, where you may not see that with any other type.
Gotcha. Thank you. That's very helpful. So I think that the presentation went through a lot of different options, but I guess what are some advice, or where might you think someone might start to do the legal prep work, while of sound mind and, thinking in particular about folks with Parkinson's disease, and sometimes there's thinking changes that go along with that. Where might they start, or what sort of legal prep work needs to be done earlier on?
So I think from our perspective, when we initially meet with someone, we have a first meeting, right? And at that first meeting, we'll ask for certain information, a completed questionnaire, existing documents that you may have done in the past that, maybe we don't know how good these documents are at this point in time. Maybe some changes need to be made. So what I can tell you is that by far and away, the people who have done the questionnaire kind of sat down and they've realized these are the people who are important to me. This is my asset situation. These are the existing legal documents that I've done. And then these are some of the professionals who I want involved in my plan moving forward. Those people coming into that first meeting with me are the ones where we are able to have the most productive 1-hour conversation about what we see as the next steps. When I have people who come to me and they've done none of that, they haven't identified who they want involved, they haven't taken a look at any previous documents. And believe it or not, I have people who come and they honestly have no idea how much money they have and how it's held and who they may have named as a beneficiary on it. And, perhaps they've done nothing in terms of accessing and identifying other professionals who may be of assistance to them. So in those situations, it's really hard to accomplish a lot from the legal perspective right away off the bat. We can certainly help you get organized, but I find when people come and they kind of have identified those 4 different areas and they've sat down and they've organized themselves, that is the best way to get a legal plan in place. So it's, I think it's true of so many things in life, like, right, the more organized you are, the easier it is going to be able to get your plan in place.
Sure. All right, so associated with that question, and this was earlier on in the presentation, but how is legal capacity determined and by whom? I know that's a consideration that will need to be addressed as well.
Okay. So that's a really interesting question, because the answer could be different depending on what context we are in. So what I would say, because I think the most common context that the people watching today would be dealing with this in, is perhaps we've got a recent diagnosis of perhaps Parkinson's, and maybe there are some memory issues, but it's just kind of starting. So usually how that works is, if someone comes to see me and I'm looking at the broader picture, I'm trying to identify and make sure that they can understand the basics of whatever document it is that they're seeking for me to prepare. Every document can have a different legal standard of capacity that I need to make sure that that person has. In my practice, if someone comes to me, I'm going to do my own kind of assessment. And I'm going to do that throughout the course of my first meeting with them, asking questions, seeing if someone's being consistent in their answers, seeing if I've had a previous relationship with them, seeing if things have changed so drastically from that previous relationship. So I would say that at first, if you're seeking to have legal documents prepared, it's really on the attorney and what the attorney feels comfortable with. I have had situations where I've had people come to me and perhaps I'm just a little bit unsure. And so what I will ask is I will often ask for that particular client to have their physician or have their a psychiatrist write up a short letter regarding their capacity, because that may be what I just need to help me be comfortable moving forward to do documents. So, some of the different documents we could be doing, we're talking powers of attorney. Well, those have a different standard of legal capacity than a will does. So, it's a really fluid situation, but I think the first step is the attorney and what the attorney feels comfortable with. And so, in that context, it's a bit different as to who makes the decision versus perhaps if we're in the guardianship context, right, where we've got a court involved and that court is going to rely heavily on a completed physician's report in making a determination whether someone has capacity or not. But I think the most common scenario this group is going to see is, hey, we want to do documents, but can we do them? We just got a diagnosis of Parkinson's. My answer is that just simply getting a diagnosis, it doesn't mean that you're prohibited from doing estate planning documents. Certainly you should get them done sooner rather than later, but really it's going to kind of be on the attorney to determine what they're comfortable with. And I have had situations where I've had to send people away because I just was not comfortable, and they perhaps weren't willing to do the things that I needed done in order to be comfortable with proceeding.
Gotcha. Thank you. Do you have any advice on how to prepare financially if long-term care insurance isn't available or realistic, maybe due to pre-existing conditions or other aspects that folks are dealing with?
So I think that the sooner you can consult with an attorney about it, the better, because it may be that, when we didn't go super in depth into Medicaid in this presentation, as Helen said, we could do an entire presentation on Medicaid, but really my guidepost when I'm trying to financially plan for the costs of long-term care is I'm looking at 5 years, right? I'm looking, are we within that 5-year window of someone, potentially needing Medicaid coverage, or are we outside of it? Because that is going to make a difference in what I can recommend to someone in terms of their planning. So by that, it's always better to have that first discussion earlier, even earlier than you may think you need it, because maybe there's something we are going to get in place because we know we've got more than 5 years to work with. If we're within those 5 years, we're kind of in a situation where I identify kind of crisis planning, where we're trying to see what can we do to try and perhaps preserve assets or extend those assets because we are within those 5 years. So unfortunately, I don't have just like a simple checklist of things that you should do, because it's really going to depend on someone's situation, their family situation, and how much money they have, how those assets are titled, what kind of assets they are, whether they have any dependents. And then also, of course, that at 5 years, right? So it's really going to depend. So I think the best advice I can give is have that consultation before you may even think that you need it, because then at least you've got that peace of mind knowing, okay, hey, at this point, there's not really anything to do, but I've been given this guideline of, hey, when we reach this point, let's have another discussion. When we reach this point, another discussion, or when, or we're actually going to move forward with a specific plan at that point.
Gotcha. And so one of the questions actually was just that about additional legal issues for Medicaid, and one specifically about a Medicaid Asset Protection Trust. Can you say a little bit more about that?
Yeah, so I think when I am dealing with Medicaid Asset Protection Trust, I'm really dealing with them in two contexts. One is I have more than 5 years to work with before I believe that that person is going to need long-term care covered by Medicaid, or I'm within the 5 years. So we do recommend them. We do routinely use them, but how much money I can actually put in that type of trust and how I have to structure it is going to depend on how much time I have to work with. You also, for example, you can't put every type of asset into a Medicaid Asset Protection Trust. When you just think of, for example, your individual retirement account or your 401k, you can't take that out of your individual name. So whether it's going to make sense for someone is going to depend on their situation, and it's going to depend on how much time we have to work with. But absolutely, they're a great tool. We do routinely use them, but it's just going to depend on whether it makes sense for someone.
Sure. All right. One more question here. So as an elder law attorney the best one to transfer assets from a principal to a spouse? I kind of wonder if I can't guess your answer to this based on the first answer, but could you say a little bit more about why that might be the best fit?
So for transferring assets just
from a principal to a spouse, or
okay. Well, of course, I'm going to say that an elder law attorney would be the best one to consult with about that. I think, if we're doing that, we're likely dealing with some form of Medicaid planning or long-term care planning, and whether it's actually possible is going to depend on the terms of the power of attorney, and whether it's recommended is going to depend on the person's specific financial as well as medical situation. So I certainly think that it would be best to consult with an elder law attorney about that, kind of for the reasons I said in the first answer, that we have our eye on issues involving Medicaid, involving long-term care that a typical estate planning attorney may not be considering.
Sure. Thank you. Wonderful. Well, I think that concludes our questions for today. I will remind folks that if we didn't get to your question, to please give us a call on the helpline or check out our website. And thank you to Melissa and thank you to Helen for all of your wonderful, wonderful advice today during the program. I want to say really quickly too that you'll receive a link with today's presentation as well as additional resources. And today, as we hit end, you will get a survey. So make sure that you click the survey and tell us what you think about today's presentation. We also invite you to join us throughout 2022 for our PD Health at Home programs. You can go to parkinson.org/PD Health to see upcoming and archived webinars. You can join us next week for Social Engagement Nutrition Part 2. And in 1 month, join us for the third installment of this series about palliative care, hospice, and end-of-life decisions. And then one final reminder that we are here for you. If you had a question that we didn't get to today, please reach out to our helpline by calling 1-800-4PD-INFO or by emailing helpline@parkinson.org. We thank you again for joining us, and thank you to our presenters for all of the wonderful information today. Stay well and join us again soon for another PD Health at Home program.